SJC-11575, Commonwealth versus Darlin Huang.
Okay. Good morning, Ms. Baranoff.
Good morning. May it please the court, Susan Baranoff, representing Darlin Huang on his appeal from his conviction of first-degree murder of his wife, Jinhua Zhu, and from the denial of his motion for new trial and reduction of verdict. I'll focus this morning on the two arguments that were first and last in my briefs. That is that the trial judge's rejection of defense counsel's Batson-Soar's objection to the prosecutor's challenge of a seventh male juror with structural error, and that a sentence of life in prison without parole on an intellectually disabled person like Mr. Huang is unconstitutional. I would be happy to answer questions about other rulings or actions in the case.
Can I start on the facts of the first one? So my understanding, there's 25 indifferent jurors, 14 men, 11 women, 7 men are the Commonwealth exercises peremptories on, and 8 women. Is that? I mean, excuse me, 3 women. Is that right?
2 out of 11 indifferent.
So it's 2 out of 11,
Jurors.
not 3
Jurors.
on the women. Okay. All right. It's kind of hard to do this on man, woman. You know, it's a little tricky, and it's also 10 years ago when the judge does this, before some of the more subtle distinctions that we've drawn come out, right?
Well, let me get right to the Batson-Soar's issue and some of the questions you seem to be raising. Yes, this case was tried in 2010, but the governing law really had its genesis in Batson and Soar's, and the more recent cases clarified what was always required. And these cases are not just a numbers game. The numbers can be significant, and they were in this case, but there are other factors that need to be considered. And our position is that this is unfortunately another case from Suffolk County in which there was a Batson-Soar's objection, and the trial judge didn't move past the first stage, didn't require the prosecutor to give an explanation for the challenge. And here, of course, the objection was not based on race discrimination, as in many of the cases, but on gender discrimination. And the court has repeatedly reiterated, and this has been a through line back to Batson, that the bar for showing a prima facie case of discrimination is very low. And that bar was met here in a number of ways. The numbers are significant. It's not just that this was the 7th peremptory challenge of a male juror. The defense counsel said it was the 7th out of 10 challenges. I count 7 out of 9, but in any event, it's clear it was the 7th challenge. So at least 70% of the peremptory challenges were exercised against male jurors.
I thought it was 7
But it's
out
not
of,
just that.
I thought it was 7 out of 14. Is that wrong?
Pardon me?
I thought it was 7 out of, he challenged 7 out of 14 males.
Out of all of his peremptory challenges, 7 were of men.
Right, but there were 14.
Were of women.
14.
But of the indifferent jurors, 7 out of 14 jurors who were male were challenged. So that was, so then I think we look at the disparity in the strike rate. And the strike rate
counsel,
for
how does that,
male jurors.
counsel, can you explain to me, what is the denominator we use? Is it?
I'm sorry?
What is the denominator that is relevant? Is it the 7 out of 14 or the 7 out of 10?
I think most relevant is the 7 out of 14 and the 2 out of 11, the strike rates.
So 7 out of 14, he strikes half.
That's 50
Yeah.
of the indifferent male jurors, but of the indifferent female jurors, 2 out of 11 were struck, so that was 18%. So that's a disparity in the strike rate. and maybe not as great as in some cases, like Hamilton and Butler, but significant nonetheless. And I think it's important that that was not the only factor that contributed to the establishment of the prima facie case. We also have in this case the situation where the defendant, a man, was in the same protected class as the juror whose peremptory challenge was disputed, another man. And the court has said in several cases that this is a significant factor among those factors that have to be considered. We also have the fact that this was unfortunately a domestic violence case, a case in which a man is charged with killing his wife. And that's the kind of case in which courts can anticipate and have seen on occasion, on more than one occasion, that there may be a preference for male jurors. And furthermore...
You mean a preference for female jurors?
Yes, I'm sorry, preference for female jurors, I misspoke. And then furthermore, we have...
So this is really a mental health case. It's not a whodunit case, or it's... Does that change the analysis?
I don't think so. It's still a case where a man has killed a woman, and
But it's not a case where we're deciding who's telling the truth about what happened there. It's a case in which we're deciding whether, you know, there's some kind of justification related to his mental health, right? I mean,
that's true, but there's still a concern that the prosecutor might feel that a man's defense might resonate more with a male juror.
Well, put that premise aside just for a moment. I'd like to get back to it if we could, but here, the problem here, in your view, it's not that 7 out of 14 males' peremptory challenges occurred. It's the differential, because that wouldn't really be unusual with half of a particular gender. It's the differential between that and the females where peremptory challenges were used. Is that right? Because 7 out of 14 males, that doesn't strike me as wow.
The situation can be somewhat different when we're talking about gender discrimination rather than a discrimination against a smaller minority such as African Americans.
Yes, that's my
But you
point.
have to look at the composition of the veneer and especially of who you have in terms of indifferent jurors. And then you, I think, have to look at the strike rate. That is significant. But so are the other factors. And
But
then
when you have, you know, this is a life felony. When you have a 50% strike rate, when you're dealing with gender, and you're dealing with a prosecutor who probably had 32 peremptory challenge, probably had 16 peremptory challenges, excuse me, it doesn't strike you on its face as that unusual. I mean, I understand your point when you want to do a comparison to the strike rate with females, but on its face, the 7 out of 14, does that strike you as, wow, that looks like a concern with 16 peremptories?
I think if that were all we had, that would not be enough, but that's not all we have. And I think the other very significant aspect of this case
can I
is
ask
that...
before, is there a case you can cite that doesn't have, that's just a pure man-woman case where the defendant and the victim are of the same race, and any cases like this? Or is this the first time we'd ever do this?
I think every case is a bit different in
I'm
terms
just
of
looking
the
for something. I'm just looking for something
percentages.
something close that just involves, again, we've got the victim and the defendant are of the same race, or at least nationality, and it's a pure man-woman case. Because it just strikes me that we're entering into even more problematic territory. Is there a case in any state where someone's done this? Or here?
Well, if I understand the court,
Looking
you're more
for-
troubled with
I'm looking
race
for a
discrimination.
case that's close. Just give me a case in which some court has decided that this is a peremptory challenge problem. I'm accepting your statistics.
The implication seems to be that gender discrimination is somehow
No, I'm
less
not.
of a
All
concern.
I'm looking for is support. Give me the best case that supports your position, where we're not dealing with this intersection of different races or other things. I'm curious.
Well, I think that the Butler case, which was the unpublished appeals court case, is a gender discrimination case, and there is a disparity in the strike rate there. And then there are other cases that this court has decided, such as, I think it's Oberle or Oberl, I can't remember, I don't know the exact pronunciation, which involve gender discrimination in jury selection. Sometimes these cases, including within Massachusetts, proceed beyond stage one. But nevertheless, there's a clear indication that there's gender discrimination at work in peremptory challenges. I hope that answered the question.
Well, again,
the other thing
if
I
I'm
think-
writing a decision ruling for you, I still don't have a case. I have a 128 from the appeals court, but I don't have anything on point. Just because of the problems with, 50% of the jurors are likely to be men or women, and this has the potential to be sort of, difficult to do, because depending on how many people come out first and other things, I don't know, I worry that this is taking us into an area where statistics may not be very useful.
Well, as I say, I don't think statistics are all that we have here. And the other striking thing about this case is that the judge just focused exclusively on the composition of the jury at that point. And at the point at which the disputed peremptory was challenged, the dispute was joined, there were 6 men and 4 women on the jury, and the judge just focused on that, and that is the kind of mistake that led to reversal in Carter and Sanchez. Granted, those were race discrimination cases, but the court can't fall into this notion that, well, if there are, enough men on the jury, then there wouldn't have been discrimination of the sort that is unlawful, because I think, as this court has said and the Supreme Court has said, the discriminatory challenge of even one juror is constitutionally unacceptable. So here we have a case where the judge applied the wrong standard, just focused like a laser on the composition of the jury, and didn't consider the other factors which are required to be considered.
Can I shift you to your second focal point, which is the intellectually disabled issue? Do we have enough here? Even in the motion for new trial filing, he still exceeds the threshold, doesn't he? He's still above 70, right?
Well, Dr. Holtzen, who did the examination at Bridgewater in 2004, put him in a range of 62 to 78, with a midpoint of 70, which would satisfy the usual cutoff for intellectual disability. So that in and of itself, I think, puts the first factor of significant limitation on intellectual functioning in play.
Now, in the motion I can't remember, does the expert in the motion for new trial say that the first person has employed the wrong test, given that he's Chinese and there are language barriers as well as other barriers here. He moves to the fourth version of this test as opposed to the third version, right?
Well, the person who did the post-conviction evaluation was Dr. Shialand.
Right.
And actually,
And he uses the fourth edition, right, not the third.
Pardon me?
He uses the fourth edition, not the third edition, correct?
right, but it's the same test, the Tony test, which both Dr. Holtzen and Dr. Shialand regarded as the most appropriate test for a man who was difficult to test because he didn't speak English, he spoke a dialect of Chinese, and he was illiterate. But they both agreed that the Tony test was the most appropriate test to use. And Dr. Shialand came up with a score that was 77, but she also, said in great detail, spoke in great detail about the significant limitations that Mr. Huang had cognitively and compared him to someone at the level of a 6-year-old child. So I think for the first factor of intellectual disability, there was certainly support in the record. The second factor has to do
Can I
with
ask
adaptive
that
functioning.
That issue with 6-year-old child, because he holds a job, he's driving, he's shopping, he's taking care of his kids. There's some evidence that he helped with math homework. How do we reconcile that with this? I mean, 6-year-olds aren't capable of doing any of that.
Well, I think you have to look at the environment in which he's functioning. He's looking after young children, but he's part of this tight-knit, extended Chinese family that surrounds him. He does shopping. Maybe he gets to China. Maybe he knows how to get to Chinatown. He does work in a series of Chinese restaurants. There's no indication, by the way, that he drove. I think the car in which he was riding during that accident was being driven by someone else in New Hampshire. There's certainly no, suggestion that he's a master chef in a Chinese restaurant, and he's surrounded by Chinese coworkers. And if you look back at his childhood as well, he is out of school at an early age. He works in the fields. I think if he were in the United States, you would probably see him categorized as learning disabled, if able to stay in school at all.
Well, that's important, because I wonder where that's important. If you could help refer to the record, because as you know, intellectual disability, the statutory definition also includes conceptual, social, and practical adaptive skills, a lack of those before the age of 18. So where are you on the record when you make you're suggesting, I think, that point?
I think that Dr. Shialand's report, which surveys the record in some detail, gives you an idea of the landscape and contains a great deal of what you're looking for, and that's in the third record appendix. That's where I would start on that. And it also hits this notion that these cognitive limitations date back to childhood. So my position would be there was enough here to show that he was intellectually disabled. If the court feels that the record is not as full as it should be or as it would want it to be before tackling this constitutional issue, I think the thing to do would be to remand for an evidentiary hearing. I did request an evidentiary hearing. The judge declined to hold one, perhaps because he thought this issue was really one for this court. And an evidentiary hearing would allow these issues to be explored more fully, and also perhaps more information about current science, about the nature of intellectual disabilities.
What test do we use to determine whether the motion judge abused his discretion in not holding the hearing? That is, what's your burden at getting to a hearing? It seems clear to me that the motion judge reviewed the entire record. seems clear to me that he reviewed also the affidavit of the expert and did not conclude, didn't do this matching of the factors on intellectual disability.
The burden under Rule 30C3 is to demonstrate the existence of a substantial issue. And we think that there was enough in the record to get over that hurdle. It seems that the judge assumed that the IQ score surmounted some arbitrary cutoff, but you have to consider both the Holtzen testing and the Shielon testing and the Supreme Court cases that talk about how you assess intellectual functioning. I also cited to the court the Supreme Court's decision in Brumfield versus Kane, which is interesting. It is a death penalty case, but the standard applied there for an evidentiary hearing is whether there's a reasonable doubt as to whether the defendant is intellectually disabled. And I would suggest that that would be an appropriate standard to use here, where life without parole is the most serious penalty under Massachusetts law, and there are similarities, as the Supreme Court has said, in the severity and the irrevocability of life without parole and death penalty. So
Well,
our
Commonwealth versus
position.
Jones points out some of the differences with death penalty cases as far as the analysis goes, but that leads to one other question, if I could please, which is, one of the things that we look at in determining whether or not under our Constitution, under the Declaration of Rights, cruel or unusual punishment is sort of contemporary values, normative values, and one of the things you look at there is what's going on around the country. Is there any other state that has applied Miller or Atkins to somebody with intellectual disability as far as a constitutional right to be considered for parole?
Both I and the amicus brief cite a Texas case, which is an intermediate level case, which has reached that issue and held that life without parole, mandatory life without parole for an intellectually disabled person is not constitutional. That's up on further review. The amicus brief also points out that some states have changed their laws legislatively because of this issue, and they also encourage the court to look more broadly internationally as it's appropriate for the court to do, and it cites the trends in international law against life without parole, much less life without parole for an intellectually disabled person. I think what's really troubling is the mandatory nature. There is just no possibility of consideration of the individual case, the individual offender, the way things are now.
Okay. Any other questions?
Thank you.
Thank you very much.
Thank you.
Good morning, Mr. McGowan.
Good morning. May it please the court. David McGowan for the Commonwealth, asking this court to affirm the defendant's convictions and the denial of his motion for a new trial. I'm happy to go in reverse or chronological order, whatever the court's preference. If no preference, I'll begin, like my sister did, with the Batson source claim. I do agree that there will be some cases where statistics become unhelpful to the court, as Justice Kafka noted. In this case, statistics, I think, are incredibly helpful in addition to all the relevant factors. Here, I don't see how this court could rule that a 50% of what, in this instance, is a binary male or female dichotomy here could be seen as a prima facie showing of a pattern, particularly in this case where, in addition to having the obvious 50%...
It doesn't have to be a pattern anymore, though, right?
Of course not. It can be a pattern of one is, maybe not a pattern, but as this court has ruled, discrimination can come with just one challenge. In this case, what the court had before it was 14 challenges, 14 indifferent males, 7 challenges. The court also had and it's not clear from the record that the judge stated orally that I find a certain number of individuals in the box. What the court knew was 10 jurors had been sat, 6 of them were male, 4 of them were female. What the court also looks to in all relevant factors, in addition to those statistics, which I think are controlling here, is there any possible characteristic neutral or non-prohibited reason for challenging this person? This juror, from the record we can glean, was a Boston College law student and was working as a research associate on law review. There was no discussion at sidebar that I can point to, but that I would suggest to the court, many litigants, both criminal defense attorneys and prosecutors, prefer not to have law students on their jurors with reasons personal.
I think, I don't know if I ever saw a prosecutor in 19 years as a trial judge leave a law student or a lawyer on a jury.
I haven't, but I'm sure there are exceptions. And
There are.
And by the way, I take it none of the females were law students or students, or?
Not that I could tell from the record. Again, this was a 2010 trial. There was an efficient system. This is prior to attorney-conducted voir dire, so some of the things that more recent cases may allow litigants in this court to analyze and really dig deep into these issues aren't present in this record. But we do have from the record for some of these conversations are nuggets of data. And with respect to this challenged juror, that is an important one. So in addition to the prosecutor's challenge strike rate of being 50% of what is a binary determination in this instance, I see it very difficult to reach the conclusion that the trial judge in this case made a clear error of judgment by not taking into all relevant circumstances. And I think the court does need to understand that.
Can I just double check? So I haven't read the transcript yet. Are any of the jurors seated students? Do you know? Because
Not that I could tell.
okay.
And I do recall this trial judge being somewhat encouraging students to sit from time to time over previous trials, but I don't believe so. And I did look for legal backgrounds also before emphasizing to the court that this was a law student.
I've just, having dealt with this prosecutor before, I've had a couple of trials where he knocks off every student, but I'm just curious in this case what the record's going to show. But
anecdotally, and again, the transcript is a little thin on some of the data that would be helpful. There didn't appear to be too many students generally, but I'd have to go back to do a deep dive here. I don't think it's one of those cases where the parties did not want students. I think in this case, a law student and a researcher on law review may have been, and there's an affirmative evidence on there, but it may have been the main rationale here. And I think because there is that possibility, this trial judge was well within her discretion to not inquire for a gender-neutral reason.
But it raises the issue that I brought up in my concurrence in Sanchez. There may be such an obvious reason. And as Ms. Baranoff points out, the bar is very low to satisfy the first step here. Why isn't it a circumstance where, out of fairness to the juror, the defendant, the Commonwealth, and the administration of justice, so that cases aren't tried over and over again, to just get an explanation? We've urged it, but why should we just skip step one?
I see wisdom in that. I know that when there's a challenge, when I'm litigating a case, I now offer it, whether it's requested or not, for this reason. It's very difficult to go back over 11 years later and divine what's going on in the courtroom. None of us in this courtroom were there, but we do have a very experienced judge. We have 2 very experienced trial lawyers, and we can't picture what they were seeing in real time there. And really the analysis is, what was the trial judge seeing? Was what the trial judge saw, based on her lengthy experience, and a judge who's very cognizant of the case law, is what she's seeing and what she decided to do in that instance a clear error of judgment? And on this record, I don't see how this court could find that. I don't see the defendant having met his burden, and I think on this claim, he should not prevail. There's no further.
What would you say to your opposing counsel's position on the differential in the strike rates? That is 7 out of 10, yeah, it's 50. but the men were struck at that 50% level, whereas the women were struck at the 18% level.
I'd say if the defense attorney at the trial raised that exact point at sidebar, the parties would probably turn to the sat jurors and already see women being sat. 60%, both women being sat for and a majority men being sat. The jury at that time was 60% men. And so even though there might be a difference in how the Commonwealth is using challenges versus how the defense is using challenges, my sister alluded to that maybe there's a preference for men from one side and women from the other. The defendant was challenging, like 5 of 6, I believe, were of women. And that's not an issue in this appeal, but in terms of what the judge is seeing in terms of strike rate and how to evaluate what's happening before her, I think that wouldn't be a very persuasive data point to carry the day in finding a pattern here if this were raised at trial. And today, I don't see it being very persuasive either.
But, you know, and this is, you're absolutely right, very experienced and talented judge who, as Justice Kafka said, you know, hasn't seen or didn't have the benefit of recent cases. But, you know, there's a reason that what's the jury look like now at this point of empanelment is last on the list of considerations. We have to be really careful with that factor, because every individual juror has a right not to be discriminated against, and the parties have a right to a fair and impartial jury. That's a sort of really not the most weighty of considerations, I guess.
I agree, and it's all relevant factors, and I think that's this test that this court has articulated, and that's the test it must articulate. There's no one thing that controls, and in this case, I'm not, to be clear, hanging my hat on the composition of the jury alone. It is in the possible alternative to using this strike, in this case, a law student, and the 50% strike rate. The strike rate itself, I think, in a binary situation when it's at 50%, I don't see how this court moves beyond that.
I just read the transcript. It's even more than that. I mean, the last 3 jurors seated are men. It's not like they just said there's a man on the jury and moved on like the cases and there's a long discussion about the student, because the judge teaches at BC. They're joking about the person being a student. The prosecutor asks about the research. I mean, I think you can move to the second issue if you want.
Indeed, Your Honor. Turning to the second sister raised by my sister, I don't see in this case, this record, that this issue is right for this court's adjudication. Might it be someday? Maybe. I don't.
But I think that's tough, though. So in Jones, we leave this issue undecided expressly, meaning we don't know what the answer is at this point. It's troubling to the court. Our cruel or unusual standard is more protective than the feds. Do we need an evidentiary hearing to figure out whether this defendant really is? I mean, based on this record, I can see why we're skeptical he is, but should we pin that point down to protect, say in the future we do make this change, we're not going to really know for sure whether this guy is intellectually disabled or not, are we? It's tough to know based on this.
And that's an important factor. If that is a data point that is tough to know, I'm not sure that record can lead to clear guidance from this court. And in this case, not only is it tough to know, it is suspect. The record itself speaks to how suspect it is. It was rejected by the jury. It was rejected by multiple experts.
But the case is not tried as an intellectual disability case. It's tried as a mental health case, but not that he's, got an IQ of under 70. This wasn't a mice and men case. It's whether he's, mentally ill case, right?
Yes, to a degree, Your Honor. I'd have to concede that. However, as the motion judge articulated in his ruling, that a lot of the evaluation that was done in the post-conviction experts' work was redundant of earlier evaluations that went on for over a decade from the murder itself to when it was ultimately tried. And where that's the case, the court doesn't have much to make that determination. And as the motion judge reviewed, determined that there is no evidence of a mental defect for this individual, and there was no clear evidence that this was even an impairment.
But the judge does a real, I mean, writes over a 50-page decision. It's very carefully done. But at the same time, he seems to accept that this person may have a 6-year-old mental functioning capacity. I'm not sure I could determine that from this record. And I guess if we've left this issue open and we haven't decided it, should we know factually whether this person, because we don't have anything from the Commonwealth on this point, do we? I mean, we have these two defense analyses that suggest he's in the range of intellectually disabled. But we don't have anything from the Commonwealth like we do on the mental health issues in the court, that he's, look, this guy's sane, he's, this is malingering or something else. But we don't have that on the intellectual disability point, do we?
Well, I think that both of those experts the defense rely on, those reports are replete with caveats. And I think the motion judge had to acknowledge that, but they, or I guess in light most of the defendant, they were doing the best they could based on the evaluations they had at their disposal and the condition of the defendant himself. This was not a battle of the experts post-conviction, but it was during the trial. And in addition to not looking into the mental state or the mental bandwidth of this defendant, because it wasn't a lack of criminal responsibility defense, it was mental impairment. So any of those things that would suggest or lead to some kind of mental deficit of this individual was explored deeply. Maybe not to as fine a point as Your Honor's inquiring about, but it was explored very deeply, and almost all of it was put before the jury. And so the motion judge in this instance had an enormous record.
The jury can't decide this based on, I mean, I haven't read, again, the whole trial record, but the jury can't decide. It doesn't know whether he's got an IQ below 70 or not. There's nothing before the jury on that.
No, but it was before the motion judge. And on this,
And so I think it's important to see what the motion judge concluded. He says, "It is troubling that a man with the intellectual ability of a 6-year-old, just above the cutoff for those with intellectual disability, will serve life without the possibility of the parole." And he says, but the SJC hasn't ruled on it. So I'm not going to do it. Bring it to the SJC, and here we are.
we are. And I think based,
So I'm troubled by your statement that this is not the case for that. I mean, if there's a question as to the intellectual disability of this particular defendant, and the law seems to be moving, or at least has made some inway into whether or not that is constitutional, why not conclude that the defendant has raised a substantial issue sufficient to get what you called the battle of the experts post-conviction? Don't we need to know, is he intellectually disabled or not?
that's assuming it can be known based on the expert reports
Well,
that
I mean, the truth can't be known. I mean, this is the way we test these things, is by, taking evidence. And here the defendant has raised enough of an issue that the motion judge, hearing this motion without any evidence, is troubled that this defendant has the intellectual ability of a 6-year-old.
Well, I think that sentence may have been inartfully phrased by the motion judge, because taking the motion judge's, and it is clear, I'm not saying that it is ambiguous, that statement of concern is clear, but I believe it's repeating the defense expert in the light most favorable to the defendant in that instance. Part of that motion judge's opinion makes two clear findings, which was the essence of the issue raised on the motion for new trial. There's no evidence the defendant suffered from a developmental or intellectual disability. That's the first conclusion of the motion judge. The second is no clear evidence he suffered from a mental illness that prevented him from appreciating the consequences of his choices or controlling his impulses. Those are the clear findings. And so when I got to the first sentence of that last paragraph Your Honor just recited, I was somewhat puzzled at the tone of it, but really it's restating the law. As the court hasn't addressed this head on, the judge is just making an observation. This is someone a defendant who clearly has some stuff going on. It took a number of years to get to court, to get to trial, and he continues to receive treatment. So that's part of the record, and it's very well established. Whether the expert report that was submitted in the support of this motion for new trial raised a substantial issue, I would say no. And as the judge outlined in his findings, that there was really nothing new here. Not only was it not new evidence, it was very much duplicative and redundant of prior work. And so if this court were to affirm the convictions and affirm denial of this motion for new trial, there is nothing in our jurisprudence that prevents the defendant from further and better establishing what this court's asking to do. But based on this record, I think remanding just as a faster way to get to this particular legal issue is inappropriate.
Well, let me pick up on the point you're raising and go back to Justice Kafker's question of the defendant. So if the finding is there's no evidence of an intellectual disability, you don't have an evidentiary hearing if the issue is not raised. If that's the judge's conclusion, when we're looking at this record, going back to the question that was asked of the defendant, what's our review of that determination, that no issue of intellectual disability has been raised?
Did the motion judge, as the gatekeeper of that exact issue, of whether or not that, in the form that it is before the court, is a substantial issue that merits an evidentiary hearing, did that judge, in finding no at this time, no based on what is before me, it is not a substantial issue? That is reviewed for an abuse of discretion. Might there be an instance in this case where that changes? Possibly. But right now, before this court on this record, it is not before the court, and certainly not in a position for the court to offer sound guidance of what I expect will be an issue the court faces someday. But on this case, I would ask you to not address that point based on this record, affirm the defendant's convictions of the brutal murder of his wife, and affirm the denial of the defendant's motion for new trial. If there are no further questions.
I actually do have one last question.
Yes, Your Honor.
On the argument of the issue of what the son said about the father and the lack of ability to refresh the recollection.
Yes.
There's an argument in the appellant's brief about past recollection recorded. And I wondered about two things. Number one, was that raised at trial? And number two, if it was raised, was there any showing as to the other foundations required for past recollection recorded about personal knowledge firsthand, and that there was a sufficient memory at the time and that it was truthful, those conditions?
I'm quite confident to say it was not raised, and that was at February 8th, page 44, ballpark area, where this was an unsuccessful refreshing of recollection. It didn't come to that point. I do know that the evidence being sought through that witness did come through another witness. Maybe not in the form the defendant was seeking, but that evidence did get before the jury that after the car accident, the defendant became, quote, crazy, he's getting worse.
The reason I'm asking is that if it never came up, then the issue is where's the substantial likelihood of miscarriage of justice when we're reviewing it? If it never came up, don't we have to say, was there a strategic reason? Was it impossible to raise it?
It wasn't fleshed out, and so I hadn't done a full analysis, but based on how Your Honor's phrased it, I don't think it would have come in as past recollection recorded in the form that I recall it coming in. But again, that it is in the transcript how it was litigated, and there was some specifics as to how it was being attempted to be introduced.
Right. And so the tape also, it's a videotape, is that what it is? Or grand jury minutes?
I don't recall, Your Honor.
Doesn't matter for analysis either way. All right, thank you.
I don't recall.
Any other questions?
Nope.
All right, thank you.
Your Honor, thank you.